And unless a last-minute settlement is reached, the fate of Arthur Andersen rests in the hands of the 12-member jury that lawyers began selecting today. Andersen has hired Rusty Hardin. He is one of the best-known criminal trial lawyers in Texas. But can a bulldog such as Hardin pull off the near impossible? Let's ask our panel of legal experts. First in Houston, Christopher Bebel. He is a former prosecutor for the Justice Department. Next up, Randall Picker, a University of Chicago law professor who is teaching a seminar on Enron that could go on for months. And here in our studio, John Coffey. He is professor of law at Columbia University. And gentlemen, welcome. And Jack, let me start with you. What are the chances of Andersen pulling out a victory in court? And if so, would it be a Pyrrhic one?
Well, I think it would only be a symbolic victory. This is a case that I think is going to trial only because Andersen has nothing to lose. And when there's no downside, you can afford to roll the dice. It's an attempt to take that long shot gamble to get a symbolic victory for the partners. But it's a long shot.
Christopher, the Justice Department has certainly gotten a lot of flack about this prosecution. Do you think they made any missteps along the way?
Well, I think the Justice Department had to make a tough call here. The Justice Department, in all likelihood, was very hesitant to go forward with this case against the entire company because there are scores of very innocent people that are going to be adversely affected by this, permanently affected by this, and in a major way. But the Justice Department made the decision to go ahead and indict the whole company. The reason the Justice Department made that call is because right now we're looking at a crisis of confidence across corporate America. People need to get a sense that they can rely on the financial statements that are disseminated by the publicly held companies, and the Justice Department has concluded that unless this type of very strong action was taken, the problem may just continue to spin out of control.
Yeah, Professor Picker, a lot of people say to me when I'm out on the street or whatever, how come no one's going after the Enron executives? Where is Ken Lay? Is he on the beach somewhere? Why was Andersen made the point firm going forward here in the beginning?
I think it's a question of the order in which you prosecute cases. The unfortunate fact of the admitted destruction of documents made Andersen the natural, easy target to chase. And so once the Andersen piece is done, then I think we'll turn to Enron. So it's about how you build a case.
And John Coffey, there we see David Duncan, the accountant, the lead auditor on the Enron account. How important is he to this Andersen case, and how big a witness will he be in the subsequent Enron cases?
Well, he's very big in both cases, and that's the real danger, the downside for the government. Because if Duncan were discredited, if there was a very effective cross-examination of him in this case, it would not only affect the Andersen prosecution, but it would potentially cripple the Enron prosecution. That's why the government may have preferred to settle if they could have had their druthers.
Any chance that they're going to settle before this thing really goes to trial?
Anything can happen, but that would surprise me. This is something that was going to settle. It would have been settling weeks ago.
And Christopher Bebel, your best guess on how the Enron prosecution will play out? Because we have Ken Lay, Jeff Skilling, all of them spinning all sorts of tales about what was going on there.
Well, I don't think we're going to see just one Enron prosecution. I think the underlying fact pattern is too complicated, too massive for a jury to get its arms around. As a result, I think we're going to see two separate prosecutions. The government is going to try and break off one part of the case and bring it to trial first, and then break off a second part of the case. My prediction is that the first part of the case will involve the LJM limited partnerships along with Mr. Fastow and his subordinates.
Yeah, and you know, Professor Picker, usually one of these people turns. Who's going to be the David Duncan of Enron?
Boy, that's a good question. I don't think it'll be Andy Fastow. I think it'll be another high-up person, someone close to Fastow who has a good sense of exactly what was going on in LJM.
You agree?
Oh, yes. I think the government has gotten cooperation from Mr. Fastow's assistant, particularly Mr. Glissad, who was the treasurer. You prosecute these white-collar cases by having someone who was in the room and can describe what was going on when we prepared this registration statement or we negotiated that merger. And I think that's what the government wants, and I think they're well on the way to having it.
Do you think any of those Enron executives will do time?
I think if they are convicted, it is very likely under the sentencing guidelines. I don't want to predict anyone's guilt, but I think I agree with the last speaker that we'll probably start with a prosecution involving Mr. Fasto and the defrauding of the company, and move from there to a prosecution of the defrauding of investors, which is a far more complicated trial.
Yeah, could go on for years probably. Christopher Bettel, do you think some of these Enron executives, excuse me, will do time?
Well, I think that they, in all likelihood, will do time. I think these criminal acts were of such a magnitude that they're actually of historic proportions. And when you look at the sentencing guidelines and you see the amount of money that was involved in the scheme, it's just about off the charts. Actually, I think it is off the charts. And so I think the question is, how much time will they see, and could there be an upward departure from the sentencing range that's suggested in the guidelines?
Yeah, because those ranges in the past have been rather narrow. All right, thank you, gentlemen.